All right, let's dive into a case from Arizona that is really going to make you think.
Yeah.
It involves two young women, Brittany Henry and Shania Richmond, who are dealing with a whole bunch of legal trouble after their apartment was damaged in a flood.
Oh, no.
They thought they had renter's insurance, to cover them, but their insurance company, Assurant, denied their claim.
Oh, wow.
And now they're stuck with over $33,000 in legal fees.
Wow, that's a lot of money.
Yeah.
So what's the deal with this case? It sounds pretty straightforward.
Well, that's the thing. It's not just a simple disagreement about a denied claim. We're going to look into allegations of breach of contract and bad faith, and maybe even some procedural mistakes by the court.
Okay, this is getting interesting.
Yeah, this case could have a big impact on how insurance companies operate
I see.
and how courts handle similar situations in the future.
Yeah, so it's not just about these two women. It's bigger than that.
Right, exactly.
Okay, I'm ready to dive in.
So the big question is, did these women get treated fairly? Was this just a miscommunication, or is there something more going on? Let's take a closer look and see if we can figure it out.
All right, let's do it.
To understand what happened, we need to go back to the beginning.
Okay.
Brittany and Shania got their renter's insurance from American Bankers Insurance Company of Florida, or ABYR, which is actually a subsidiary of Assurant.
Okay, so we've got a parent company and a subsidiary. Got it.
Yeah, we'll get to why that matters later.
Right.
But for now, let's focus on what happened.
Okay.
Their policy was canceled because of a missed payment.
That happens.
But Brittany and Shania claim they never received a cancellation notice.
And then what?
And then a flood damaged their apartment.
Oh, no.
They filed a claim, and it was denied.
Oh, wow.
And to make things even worse, their landlord started eviction proceedings.
This is a nightmare.
It was just bad news after bad news.
Yeah, that's rough.
So they ended up suing, alleging breach of contract, bad faith, and negligence.
Makes sense.
Now remember those exhibits the defense submitted? They actually have some pretty important evidence that supports the plaintiff's claims.
Really? How so?
Well, the defendant's own exhibits show that Brittany and Shania gave the correct address for their policy, which directly contradicts the defendant's claims that there was a miscommunication.
So they're saying they sent the notices, but they had the right address all along.
Exactly. It also suggests that those cancellation notices might have been sent to the wrong place.
No, that's not good for the defense.
Nope.
So what else?
Well, on top of that, there's evidence of returned mail from the USPS.
Really?
Yeah, which further backs up their story that they never got those cancellation notices.
So the evidence is piling up in favor of the plaintiffs.
It really is.
Interesting.
Like the defendants accidentally gave the plaintiffs evidence to help their case.
That's a pretty big mistake.
Yeah, it is.
So what happened next?
Okay, but it gets even crazier.
Oh, no.
Right before the oral arguments were set to begin,
Yeah.
the judge in the case was switched. Judge Ostrowski, who was originally on the case, was replaced by Judge Whitten.
And did that affect the case?
You bet it did.
How so?
Just a few days before the hearing, Judge Whitten decided to strike the plaintiff's motion for summary judgment from the record.
What? Why?
He said there were formatting issues in the statement of facts.
A formatting issue.
Yeah, can you believe that?
That seems a little picky,
Right.
especially if it could derail their whole case.
Exactly. And get this, neither Judge Ostrowski nor the opposing counsel had any objections to the formatting before.
So it seems like Judge Whitten was looking for a reason to strike it.
Yeah, it's pretty suspicious.
Wow, so what happened to the plaintiffs?
Well, the court did grant them a 30-day extension to refile their motion with the correct formatting.
Okay, so they had a chance to fix it.
You'd think so, right?
Right.
But here's the kicker.
Good.
The court ruled in favor of the defendants before that 30-day deadline was even up.
Wait, what?
They basically took away the plaintiff's chance to present their case with the corrected formatting.
So they gave them an extension but then ruled against them before they could use it.
Exactly.
That's not right.
It really isn't.
It seems like they didn't get a fair chance.
Yeah, this whole situation raises some serious questions about due process
I agree.
and whether the plaintiffs were really given a fair opportunity.
So this 30-day issue is a big deal then?
Huge. It's the core of the plaintiff's argument that the ruling was a mistake and inadvertence under Arizona law.
They're trying to get the judgment overturned because of this procedural problem.
Exactly.
This case just keeps getting more and more complicated.
It really does. We've got a 30-day procedural mess, a questionable judge change,
Yeah.
and the potential for negligence on the part of the defendants.
It's a lot to unpack.
It is. But before we jump into the legal implications of this 30-day situation, let's take a quick break.
Sounds good.
We'll be back in a moment to dig deeper into this fascinating Arizona case.
All right, so we're back and ready to really dig into this 30-day issue.
Yeah, I mean, it just doesn't seem right that they were given this extension and then denied the chance to actually use it.
Exactly, raises serious questions about fairness in the legal system.
But didn't they technically mess up by not following the formatting rules?
Well, yeah, courts do have these rules for a reason, to keep things organized and clear. But usually, minor formatting issues can be fixed without throwing out the whole motion.
Especially since the previous judge and the other lawyer didn't seem to have a problem with it.
Right, exactly.
So it feels like Judge Whitten was maybe looking for an excuse to get rid of their motion.
It's possible, and the fact that this happened right after the judge change is pretty suspicious.
So are you saying that different judges might handle things differently?
Oh, absolutely. Judges have some leeway in how they apply the rules. It's called judicial discretion.
So that could explain why this formatting issue suddenly became such a big deal.
Yeah, it's definitely a possibility. We can't know for sure what Judge Whitten was thinking.
But either way, it all happened before the plaintiffs could even use their 30-day extension to fix the formatting.
Exactly, and that's the real problem here. They were denied a fair chance to present their case.
It almost feels like that 30-day extension was just a way to make things look fair without actually giving them a chance.
That's one way to look at it. The whole situation is definitely pretty messed up.
So we've got this 30-day issue, the strange judge change, and the possibility that the defendants were negligent.
Yeah, it's a lot to keep track of.
Let's go back to something you mentioned earlier, the prevention doctrine.
Oh, right, yeah.
How does that fit into all of this?
Well, the prevention doctrine basically says that you can't blame someone for breaking a contract if you stop them from fulfilling their part of the deal.
Okay, I think I get it.
Like, imagine you and I agree that you'll bake me a cake for my birthday,
Okay,
but I give you the wrong address so you can't deliver the cake.
right.
Is it really fair for me to get mad at you for not bringing the cake?
No, not if you gave the wrong address.
Exactly. And in this case, the plaintiffs are arguing that the defendants might have done something similar.
By sending the cancellation notices to the wrong address.
Right. They're saying that if they had known about the cancellation, they would have paid their premium and kept their coverage.
So it's the insurance company's fault that they couldn't pay.
That's what the plaintiffs are claiming. They're saying that the defendant's mistake prevented them from keeping their policy in good standing.
And we know they had the correct address because of those exhibits the defense submitted.
Right, and there's evidence that the cancellation notices were returned as undeliverable.
So the defendants might have accidentally helped the plaintiff's case by trying to defend themselves.
It's pretty ironic when you think about it.
Okay, so we've got this prevention doctrine argument on top of everything else.
Yeah, it's a complex case for sure.
And now we need to talk about the relationship between AB, the company that issued the policy, and Assurant, the parent company.
Right. Let's unpack that a little.
Because the plaintiffs say they were mostly dealing with people who said they were from Assurant.
Even though their policy was with ABIC.
Yeah, so it's kind of blurry who they were actually dealing with.
So the question is, can Assurant be held responsible for what ABIC did?
Right, especially since they didn't seem to be keeping things very separate.
Exactly. Courts often look at how much control a parent company has over its subsidiary.
So if Assurant was making the decisions for ABIC, they could be in trouble.
That's the argument, yeah.
This is getting more and more like a detective story with every detail we uncover.
It definitely keeps things interesting.
So we have this 30-day issue, a possible case of prevention doctrine, and now we're looking at corporate liability.
Yeah, we've covered a lot of ground.
In the last part of our deep dive, we'll really dig into this question of corporate responsibility.
We'll see if Assurant could be held accountable for what happened here.
And we'll explore what this case could mean for the insurance industry and consumers like us.
It's a big deal, and we'll break it all down in the next part.
Okay, so we're back for the final part of this deep dive, and we've got to figure out this corporate liability thing.
Right. Can Assurant, the parent company, really be held responsible for what ABIC did?
Yeah, it seems like the plaintiffs think so.
And they might have a case. Remember, they're saying they mostly talked to people who said they were from Assurant?
Even though their policy was actually with ABIC.
Exactly. So it gets kind of blurry.
Yeah, who are they supposed to think they're dealing with?
That's a good point. And courts look at that kind of thing, you know?
Like if Assurant was calling the shots for ABIC.
Right. They want to know how much control the parent company has over the subsidiary.
So if Assurant was really running the show, they might be in trouble.
Exactly. And it's all about transparency, too.
Yeah, if a big company is involved, people should know who they're really dealing with.
Absolutely. And meanwhile, these two women are stuck with over $33,000 in attorney fees.
That's a lot of money.
And it all started with a formatting issue and maybe some miscommunication.
It's scary to think that something so small could turn into such a big problem.
Definitely. It makes you wonder about the whole system.
So what do you think this case means for consumers like us?
Well, it shows how important it is to know your rights.
Yeah, and to read the fine print.
Absolutely. And don't be afraid to ask questions.
That's good advice.
Because even something that seems simple can turn into a legal nightmare.
Yeah, this whole case has been a real eye-opener.
It's like we started with a denied insurance claim and ended up on this journey through the legal system.
With twists and turns and surprises at every corner.
And it's not just about these two women in Arizona.
It's about all of us.
It shows how things can go wrong and how important it is to be informed.
We need to know our rights and be ready to stand up for ourselves.
Absolutely. And I think that's the main takeaway from this deep dive.
Knowledge is power, right?
Exactly. Keep learning, keep asking questions, and keep the conversation going.
That's what we're here for.
Thanks for joining us.
And remember, every case has a story. And sometimes those stories can teach us all a valuable lesson.